This is the sixth lecture on the topic of interpretation of Section 6 of the Hindu Succession Act. Sixth part. We are discussing this topic on the background of judgment of the Supreme Court in the case of Vinita Sharma versus Rakesh Sharma. This judgment was delivered by the bench of 3 judges, that is larger bench. This case Vinita Sharma versus Rakesh Sharma, it is reported in All India Reporter year 2020 Supreme Court page 3717. So in this case this larger bench of the Supreme Court, of the Honorable Supreme Court, has overruled the views which are contrary to this decision, which were expressed in previous case of the Supreme Court, the judgment of the Supreme Court in the case of Prakash versus Phulavati. So this present case, judgment of this present case in the Vinita Sharma versus Rakesh Sharma, it overruled the earlier decision given in the case of Prakash versus Phulavati. A division bench of the Honorable Supreme Court in the case of Prakash versus Phulavati held that Section 6, that is substituted new Section 6, is not retrospective in operation. And it applies when both Coparcenary and his daughter were alive on the date of commencement of Amendment Act, that is 9 September 2005. So in this case of Prakash versus Phulavati, the court held that the substituted Section 6 would apply when the father of that daughter, father co-parcel of that daughter, was alive on the date of commencement of the Amendment Act, that is 9 September 2005. Therefore, in the said case of Prakash versus Phulavati, the court held that the provisions of the substituted Section 6 are prospective in application. Even though the rights under the new substituted Section 6 can be claimed with effect from 9 September 2005, its provisions are retroactive application. As they confer benefits which are based on the antecedent event. So in this case of Vinita Sharma versus Rakesh Sharma, Honorable Supreme Court held that Honorable Supreme Court held that even though the rights under the new Section 6 can be claimed with effect from 9 September 2005, its provisions are of retroactive application as they confer benefits which are based on the antecedent events, that is previous events. So, any statute can have three kind of application. First one is prospective application, another is retrospective application, and this is third one is retroactive application. In case of prospective application, the prospective statute operates from the date of its enactment, conferring new rights. So, prospective application from the date of the commencement of the new act, amended act, that is prospective. Retrospective application, that is the retrospective statute operates backward and it takes away or impairs vested rights which were acquired under then existing laws. So in case of retrospective application, the rights which were already conferred by the previous existing laws, it can be impaired or it can be taken away by the retrospective application of the new statute. That is retrospective which operates backward. Prospective which operates forward from the date of the commencement of the act. But retroactive application, which is recognized and held in this case of Vinita Sharma versus Rakesh Sharma, retroactive application, it is one which does not operate retrospectively. It operates in future, but its operation is based upon the character or status which arose earlier. So retroactive status, that is the substituted section 6, it do not apply retrospectively. It do not apply from the backward. It operates in future, that is from the commencement of this amended substituted provision. But its operation is based upon the character or status which arose earlier, previously, that is antecedent event. So in substituted section 6, the expression daughter of a living co-partner has not been used. Daughter of co-partner, this wording has been used, but daughter of living co-partner, this wording has not been used. Right is given under section 6 subsection 1 clause A to the daughter by birth. Right is given by birth. However, declaration of those rights which are based on the past event, that is of a birth, was made on 9 September 2005. So right is given to a daughter by birth, but this right get declared. This right get declared on the 9th September 2005. Thus, under the amended section 6, the right is conferred by virtue of birth, that is by reason of birth, and from the moment of birth, which is an antecedent event. So, right which is given under the substituted section 6 to a daughter is why those right is given to the daughter because of her birth in the family. From which moment she has got that right? From the moment of her birth in that family. And this is antecedent event, previous event. This right is recognized or declared from 9 September 2005. However, a daughter who is born before the amendment can claim her rights only with effect from the date of the amendment, that is 9 September 2005, subject to sieving of any past transaction as provided in the proviso clause of subsection 1, subsection 1 read with subsection 5 of amended section 6. Means the substituted section 6 confers a right of a daughter, confers a right on the daughter of a co-partner to claim her co-partner right such as a right to partition. She can claim her right with effect from 9 September 2005, but she has got the status of co-partner and she has got the rights of co-partner from the moment of her birth, and by virtue of her birth, even though she has born in the family before this amended provision came into force. So, as I said earlier, for the claiming the right for a daughter, there must exist the coparcenary and coparcenary property. Therefore, by virtue of this amended provision, she can claim the rights, but subject to saving of past transaction, as it is made clear by provision under subsection 1 and subsection 5. It means that if there had been actual partition even before commencement of the Amendment Act, then daughter cannot claim partition once again merely because she has been recognized now as a co-partner. Then the date of the commencement of the Hindu Succession Amendment Act of 2005 is the 9th September 2005. Proviso clause to subsection 1 of substituted section 6 says that, proviso clause to subsection 1 says that nothing contained in said subsection shall affect or invalidate any testamentary disposition of property which had taken place before the 20th December 2004. Testamentary disposition. A co-partner is entitled to dispose of his undivided share in the co-partner property by making a will. When a co-partner makes a will, then it is testamentary disposition. A co-partner is entitled to dispose of his undivided share in the co-partner property by making a will. Here it is to be noted that the will takes effect only upon the death of the testator. Testator means a person who executes a will, executes or makes his will. But that will takes effect only upon his death or upon the death of the testator. That means when he executes the will, it does not take effect immediately. It take effects only after the death, upon the death. Therefore, only in such cases where the testator dies before the 20th December 2004, testamentary disposition of his undivided interest will remain unaffected by the substituted provisions of this new section 6. That means, suppose one co-partner has executed a will for disposing his undivided interest in the co-partner property, then in such case, if he dies before the 20th December 2004, then said disposition, testamentary disposition, will remain unaffected. However, if suppose any such co-partner who executes his last will, although before the 20th December 2004, but who dies after the said date, then in that case, testamentary disposition of his interest shall remain subject to substituted provision. Meaning thereby, suppose one co-partner executes his will, suppose in the year 2003, and suppose he dies in the year 2006, so his will take effect in the year 2006, but he has executed his will in the year 2003. Then in this case, that testamentary disposition of his interest shall remain subject to substituted provisions of this new section 6, meaning thereby that while calculating or ascertaining his undivided interest by way of notional partition, it is also to be kept in mind that now his daughters are also the co-partners. Means while making a notional partition, we have to allot an equal share to a daughter also, because she is also co-partner, while ascertaining his undivided interest which he wishes to dispose of through his will. Here it is to be noted that devolution of undivided interest by way of inheritance, that is in absence of any will of any such co-partner who dies before 9 September 2005, shall be as per the earlier section 6 of the Act of 1956. Now, interstate succession, disposition of undivided interest of deceased co-partner by way of interstate succession, that is inheritance. So suppose in case any co-partner who dies before the 9 September 2005, then his undivided interest shall devolve as per the provision of earlier section 6. Suppose any co-partner dies in the year 2004, then his undivided interest shall devolve by way of inheritance as per the provision of earlier section 6 of the Act of 1956. However, before the 9 September 2005, whether undivided interest of any deceased co-partner will devolve either as per the rule of survivorship or by way of succession, it all depends upon the fact that whether or not he had left behind any class 1 female relative or any class 1 male relative claiming through such female relative. Means suppose if any co-partner dies before the 9 September 2005, say for example in the year 2004, so earlier section 6 will come into operation, and it says that when any co-partner dies, his undivided interest shall devolve by rule of survivorship. This was the general rule, but there was one proviso clause. It says that when he left behind him any class 1 female relative or class 1 male relative claiming through such female relative, then his undivided interest shall devolve by way of, not by way of survivorship, but by way of testamentary or intestate succession. It is so because in case of the death of a co-partner before the 9th September 2005, we have to consider the provisions of earlier section 6, especially the proviso clause thereunder.